back from lunch, everyone. We're going to get started with the next panel, the impact of Dobbs v. Jackson Women's Health Organization and reproductive rights in Hawaii. Sarah and I are absolutely honored to be moderating this panel.
So 9 months ago, the United States Supreme Court in Dobbs v. Jackson Women's Health Organization overturned Roe v. Wade and Planned Parenthood v. Casey, holding that there is no constitutional right to an abortion, refusing to even recognize an exception for cases of rape and incest, and paving the way for states to ban abortion. And abandoning nearly 50 years of precedent, the majority, authored by Justice Alito and joined by 4 other conservative justices, stated that the substantive right to abortion was not deeply rooted in our nation's history or traditions. Dobbs marked the first time in history that the court has taken away a fundamental right. As the dissent by Justices Breyer, Sotomayor, and Kagan recognized, after today, young women will come of age with fewer rights than their mothers and grandmothers had. The majority accomplishes that result without so much as considering how women have relied on the right to choose or what it means to take that right away. Immediately, sorry, Suhyeon.
That's okay. Immediately after the Dobbs decision, about half of the states took action to severely restrict abortions, ban abortion outright, or had trigger bans taking effect. Legal challenges to the bans are pending in state courts across the nation as we speak, while millions of women, particularly women of color, continue to endure the harsh consequences of their reproductive rights being destroyed. Women are either forced to travel hundreds and sometimes thousands of miles to access abortion care, and those without the means to travel may self-manage an abortion or carry their pregnancies to term against their will, a violation of their human rights. While Hawaii has statutory protections in place and is acting to bolster the state's policy to protect reproductive autonomy with Senate Bill 1, we have and continue to face barriers to access to abortion care, especially in rural communities. Many believe that this devastating decision will reverberate for generations. In the words of the dissent, whatever the exact scope of the coming laws, one result of the Dobbs decision is certain: the curtailment of women's rights and of their status as free and equal citizens.
Throughout the process of organizing this panel and the symposium, we found ourselves returning to 2 broad overarching questions. Where are we post-Dobbs, especially in Hawaii? And where do we go from here? It is difficult to think about, and we grappled with many related questions. What can we do to fight this injustice? How do we talk about this case with all of its nuanced angles and far-reaching implications? How can we fairly, accurately, reasonably, and judiciously frame this issue for a panel conversation? How can we uplift and amplify the voices of women, especially women of color, not only by inviting them to the table, but by really listening to them and meaningfully reflecting their narratives as part of this important conversation? This has seemed like a momentous, almost impossible task, but it is important, sensitive, and challenging work, but also work that is so well worth it and very important.
This topic could easily be a multi-day symposium. 1 hour only begins to scratch the surface to address these difficult and important questions. But after significant thought and reflection, we also came to the conclusion that the most important thing is to start to spark further conversation within the law review, the law school, and within our broader community. That is our intention today, to start to open safe spaces in our law school community to engage with and talk about this difficult case and these important issues in a thoughtful, meaningful way. And hopefully to serve as a call to action to support and empower women in our community, particularly in Hawaii. Likewise, we recognize that these ideas and perspectives are adding to ongoing conversations and actions. We've been encouraged and inspired to see other law reviews, journals, and legal institutions across this country doing the same. For example, here are some of the titles and topics of other symposia, past and future. After Roe and Dobbs, seeking reproductive justice in the next 50 years, the impact on poor women with other children, the impact on various healthcare fields and privacy concerns, and finally, a recent keynote address, Dobbs and Democracy at the University of Virginia, delivered by NYU law professor Melissa Murn. Also this year's Dan and Maggie Nguyen Chair in Democratic Ideals, who will be speaking later this month at Richardson on constitutional law. Each of these conversations provide a different perspective. Each seeks to unpack an important impact of Dobbs.
This brings us back to the focus of our panel today, which centers on two overarching questions. Where are we post-Dobbs, especially in Hawaii, and where do we go from here?
Today, we gathered a diverse group of voices, including those on the front lines, to explore these questions at this important moment, recounting where we've been, describing where we are, and envisioning where the law of reproductive rights should go next. Each of the panelists will provide a short overview and presentation on these different angles to these issues. You will hear from Professor Carole Petersen, a gender law and international human rights scholar at the William S. Richardson School of Law here at UH. Much of Professor Petersen's scholarship focuses on the relationship between reproductive autonomy and the right to equality. We also appreciate her zooming in from the East Coast while attending the Commission on the Status of Women meeting. She'll present an overview of the legal landscape from a feminist perspective, speaking about her forthcoming symposium article on the impact of Dobbs v. Jackson Women's Health Organization.
Second, you will hear from Deputy Solicitor General for the state of Hawaii, Kaliko onālani Fernandes. Much of her professional career has been devoted to appellate litigation and constitutional law in state and federal court. Among her numerous accolades and recognitions, Kaliko was named one of the best LGBTQ+ lawyers under 40. She follows the US Supreme Court and the legal issues arising in the reproductive rights space post-Dobbs. She will discuss several important points about the Dobbs decision and developments at the state level following Dobbs.
Then you'll hear from an ally to women and public interest lawyer, Wookie Kim, who is the legal director of the ACLU of Hawaii. Wookie is leading local and national efforts to litigate cases in state and federal courts to protect civil rights and liberties, including abortion issues, and will speak about his experiences in the trenches and the litigation around medication abortion pre and post-Dobbs. Wookie was also my first-year legal writing professor. And finally,
you'll hear from Nadine Ortega, a graduate of the William S. Richardson School of Law, Ilocano instructor here at UH Manoa, and a PhD student in political science, specializing in Indigenous politics and law and policy. Nadine is an activist working in the community. She is also the president of Our Hawaii and is currently organizing with Revolutionary Mothers on issues relating to reproductive justice and Hawaiian and heritage language education in the public schools.
Each panelist offers a different and unique perspective.
There are many other perspectives and voices to this important conversation. Unfortunately, some important voices representing in part the perspective of women in color and those of on-the-ground activists were unable to attend the symposium last minute due in part because of their important roles in these types of legal issues.
With that, we are pleased to welcome Professor Carole Petersen's presentation on her forthcoming article about the impact of Dobbs to lay the legal landscape of the decision for our panel.
Thank you very much. I'm going to say in advance that if you lose me, it's because I keep getting messages that my internet is unstable. There's a bit of a storm outside. So if you lose me, that's why. And I'm going to share my screen. Can everyone see the slides?
Yes, we can.
Good. So this is going to be a very quick, I think I have 10 to 12 minutes summary of my article. And if anyone would like to see the article before it's published, I'm happy to share it with you. In advance, I would like to thank the organizers of the symposium for inviting me and also all the help that I've gotten from the executive editors with the article. And I'd also like to thank Professor Linda Krieger, who gave me some very helpful comments on an early draft of the article. And I haven't been able to respond to all of them, but eventually, in some perhaps future articles, I'll respond to all of Linda's very insightful comments. So although individuals of diverse gender identities can become pregnant, my article focuses on the impact of Dobbs on women's right to equality. And I do so because restrictions on abortion have always disproportionately affected women, and because they also reflect and perpetuate stereotypes about women's role in society. And many feminist scholars have complained openly about the fact that Roe v. Wade never really did focus on the sex discrimination that's inherent in bans on abortion. Rather, Roe v. Wade applied a gender-neutral right to privacy. And that's understandable because at the time, litigation was really just beginning on sex-based classifications. And so it was actually considered a strategic way to address the issue. But to some extent, it always made the jurisprudential foundations of Roe rather fragile. The Casey case, although Casey got rid of the trimester framework and only, in fact, instead put in this undue burden standard, Casey arguably broadened the jurisprudential foundations. And that is because Casey v. Planned Parenthood relied not just on liberty, but also on the intertwined concepts of liberty and equality. And this interpretive approach was further developed in many cases on LGBT rights, and it's often referred to as equal dignity, or the double helix of the due process and equal protection clauses. The idea behind equal dignity, which was developed particularly in the jurisprudence of Justice Kennedy, was that you could not just look at what liberty meant to the white men who drafted the 14th Amendment. Rather, you had to look at it through the lens of equal citizenship now. And what does liberty mean to women now when they are entitled to full citizenship? But the truth is, the concept of equal dignity never really was fully applied in the context of abortion rights. And Justice Ginsburg used to complain about this frequently. And I think there's a lot of reasons for that. I explore it more in my article. Some of it has to do with the narrative of equality, competing narrative that has been articulated by the anti-abortion movement, but I really don't have time to go into that right now. The other difficulty with the jurisprudence since Roe v. Wade is that the US Supreme Court never expressly overruled two cases. One is Washington v. Glucksberg, which sets a very rigid test for unenumerated rights. And the other is Geduldig, which was very problematic for arguments that laws that discriminate on the basis of pregnancy are in fact a form of sex discrimination. And many of us thought that these two cases were sort of dead and buried because they had certainly been strongly criticized and arguably had fallen away under the jurisprudence of Justice Kennedy particularly. But as you'll see, if you read the article or if you read the Dobbs case, they've come back to haunt us. So what I've titled this slide is Glucksberg Rules, and that's because Glucksberg really comes back in the majority opinion. And Glucksberg set this very rigid test, saying that an unenumerated right is only protected by the Due Process Clause if it is deeply rooted in our nation's history and implicit in the concept of ordered liberty. The Supreme Court then also applied the Glucksberg test in a highly selective manner. And by that, I mean basically the Supreme Court majority discounted evidence that women did practice pregnancy termination in early US history when pregnancy and childbirth were overseen by female midwives. It was well known that women often grew herbs or took herbs to terminate a pregnancy, to bring on the menses, which is how it was termed then. Under English common law, abortion was not considered a crime prior to quickening. The Supreme Court also discounted evidence that was put forth in the case on the discriminatory motives for criminalizing abortion in the mid to late 1800s. In other words, there was really no attempt by the majority to apply equal dignity or subordination theory to the Due Process Clause. The majority also rejected a separate argument, which was put forth in an amicus brief by equality scholars, that the Equal Protection Clause can provide an independent basis for upholding women's right to abortion. Once again, they cited this old case. There's very little discussion of it in the majority opinion, just enough to dispense with the argument. And then finally, under the jurisprudential heading, I would say that equality scholars are also concerned that there may be a broader impact of this case, because the majority also noted that women are not without electoral political power, and that indeed women now vote at higher rates than men. And therefore, presumably, we can protect our rights in the state legislative and federal legislative levels. We don't need special judicial protection. And some scholars are concerned that this may be intended to set the stage for a future holding that women are no longer a discrete and insular minority that deserves special protection under the Equal Protection Clause. So that's a quick summary of the jurisprudential issues. Then the rest of my article focuses more on practical impact. And the truth is, for a lot of women, including women who reside in Hawaii, Dobbs may, in the immediate future, may actually lead to better protection for reproductive rights. And that is because women have become very politically active on this issue. And we're seeing some surprises. Some very conservative states like Kansas defeated a proposed constitutional amendment to take away the right to abortion. Michigan, where I was born and raised, approved a constitutional amendment to protect abortion rights. And that's a true swing state. We also have bills that are pending in Hawaii. It's a liberal state, but to be honest, the law on abortion needs updating, and it may be because of Dobbs that the law will get updated. We're also seeing very creative litigation in the state courts. In my article, I've cited a case in South Carolina where the Supreme Court held that a ban on abortion violated the state constitution's right to privacy. What's interesting about that case is that although South Carolina has an explicit right to privacy, there was a pretty strong argument made on the other side that really the drafters of that amendment were thinking more about informational and reputational privacy, not abortion. And the court said, that's doesn't concern us. We're going to look at what it means now in the context of women actually enjoying a right to equal citizenship. And the court applied equal dignity theory. We're also seeing, of course, lots of cross-border services. And I know my other panelists are going to discuss some of this, so I won't spend much time on it. But the fact is that self-managed abortion is very common now, very safe, very effective. And although some states are threatening perhaps to try to apply their bans on abortion extraterritorially, which I think is a real stretch, we're also seeing states like Hawaii either enact shield laws or issue executive orders to protect people from that extraterritorial prosecution. In my article, I discuss some of this conflicts between states that may develop as a result. I mean, if, for example, Hawaii refuses to extradite an abortion provider, maybe another conservative state will refuse to extradite some other accused criminal to Hawaii. These sorts of conflicts could eventually go up to the Supreme Court, which means that Justice Alito and Justice Kavanaugh's predictions that, oh, we're done with abortion cases, clearly, that's not the case. There's going to be a lot of litigation that will likely work its way to the Supreme Court. We also have competing litigation, which I'm sure many of you have read about in the press, where a conservative group is trying to get a national injunction against the main medicine that's used for abortions, mifepristone. And then we have competing litigation by liberal attorney generals who are arguing that the FDA has been regulating the drug too strictly. So these cases may also eventually work their way to the Supreme Court. But I want to emphasize that even if mifepristone were banned in the United States, which I think is very unlikely, but even if that happened, women will still obtain it from overseas. There's no question that they will. It's very difficult to police transnational mailing of pills. Now, I've got two more quick slides. I know I'm running short on time. Essentially, what I want to argue here is that Dobbs is probably not going to lead to a significant decrease in the number of abortions in the United States. There are just too many ways to get around these bans. Anti-abortion activists are very frustrated by this. Some of them, not all, but some are lobbying for increasingly harsh laws that will criminalize women rather than the providers. And this is actually a big divide within the anti-abortion movement. So it'll be interesting to see how it plays out. Regardless, the disproportionate impact of Dobbs and these bans on abortion will fall on women of color, women living in poverty, women without access to the internet will find it more difficult to obtain abortion pills, and women living with disabilities. Indeed, as my article explains, these women have already been targeted for prosecution even before Dobbs. Some women cannot take abortion pills. Other women require surgical abortions because the pregnancy is too far advanced. And we have already seen this latest lawsuit filed by 5 women from Texas who were injured both emotionally and physically because they could not get timely emergency abortion care in the state of Texas. Final slide. At the end of the article, I suggest that while in liberal and even swing states, I think women will be able to protect their right to abortion, access abortion care eventually. It will take time, but I do think even in the swing states, the political process will finally support women's right to access abortion. The question is what happens in the really conservative states. In those states, I do think that there are Republicans who would like to compromise, because they are realizing now what happened in the midterms. They realize that tragedies will occur. And what the most telling example perhaps is what happened in Ireland, right? A woman died during a septic miscarriage. It was too late to bring her to England for the treatment she needed. She begged the doctors for an abortion. She knew she needed one. But because they were unsure about the guidelines, even though the Irish Supreme Court had said you can do an abortion to save a woman's life, they weren't sure whether they could act and how soon, and she died. And the women took to the streets in Ireland, and that is why Ireland has a constitutional amendment now protecting the right to reproductive autonomy. I think some Republicans would like to avoid these situations, and therefore I think there may be some opportunities for women's groups and advocates to lobby them and perhaps reach some compromises. They will be unsatisfying from a feminist point of view because they will not entrench a right to reproductive autonomy, but they might actually provide for some compassionate exceptions and decrease the harm for these women in very conservative states. Thank you very much.
Mahalo, Professor Petersen, for setting the stage with your impactful scholarship and for offering your expert perspective through the international human rights lens. Next, we'd like to invite Kaliko Fernandes, Deputy Solicitor General for the state of Hawaii, to share brief reactions as well as her valuable insights as a constitutional law practitioner, highlighting a few of her key takeaways from the Dobbs opinion and its effect on other laws.
Thank you, Sarah. I'm happy to be here with you all today and grateful for the opportunity to discuss these important issues with you all. I want to just start by noting that I'm here today in my personal capacity, not on behalf of the state, and my comments today are in that capacity. So now in my remarks, as Sarah previewed, I'd like to focus on a few key points and draw out a few conclusions, takeaways, or things to consider. The first few are directly related to the Supreme Court's opinion in Dobbs. So first, the court's methodology. The Dobbs court says that for a right to be protected by the Due Process Clause, it must be deeply rooted in this nation's history and tradition. We see the same sort of elevation of history in Bruin, for example, the court's case about the public carry of firearms. And this methodology purports to require that something be traced back to the 18th or 19th century. And, in this approach to constitutional analysis, it is worth thinking about whose rights get elevated, whose rights are deeply rooted in our nation's history and tradition, those of women, people of color, members of the LGBTQ+ community. As the dissent in Dobbs notes, the ratifiers, both in 1868 and when the original Constitution was approved in 1788, did not understand women as full members of the community embraced by the phrase, "we the people." Those responsible for the original Constitution, including the 14th Amendment, did not perceive women as equals and did not recognize women's rights. So when the majority says that we must read our foundational charter as viewed at the time of ratification, it consigns women to second-class citizenship. Now, the Fifth Circuit's recent decision in United States versus Rahimi is a striking illustration of this. There, the Fifth Circuit addressed a federal law that bars individuals subject to a domestic violence protective order from possessing firearms. The court found this federal law to be unconstitutional under its historical analysis, writing that the statute is an outlier that our ancestors would never have accepted. This is the result, despite the fact that it has been shown that the presence of a firearm drastically increases the risk to victims of domestic violence. And again, if we are effectively confined to addressing only that which those in power in the 1780s and the 1860s thought to be problematic, think about where that leaves us and think about who will be afforded the Constitution's protections and who will not. Now, over the course of the term, the court also was not itself consistent as to which history or which period of time matters. As just one example, in Dobbs, the majority went as far back as the 13th century, even though in Bruin, the court says that historical evidence that long predates ratification may not illuminate the scope of the right. So in short, although this historical methodology may be pitched as objective at many notable moments, it appears quite selective. Now, second, what does the Dobbs decision portend for other rights like contraception and same-sex marriage? Justice Alito's majority opinion says that the decision does not imperil other rights and precedents, but do we believe that? The same rationale the court uses to demolish Roe and Casey could be deployed against other substantive due process rights. So should we take the court's assurances that those other rights are somehow not on the chopping block too? In his Dobbs concurrence, Justice Thomas at least makes plain what his intentions are. He says, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Justice Alito's assurances in Dobbs are particularly suspect as to Obergefell. In October 2020, he and Justice Thomas strongly signaled their willingness to overrule Obergefell in a statement respecting the denial of certiorari in a case brought by Kim Davis. If you folks recall, Kim Davis was a Kentucky clerk that refused to issue marriage licenses to same-sex couples. We've seen other instances where the court says a ruling is narrowly limited. For those of you familiar, think of Trinity Lutheran and playgrounds, but down the road, that limitation does not necessarily hold up. So point being, there's a reason not to put too much stock into the Dobbs majority's alleged limitations. Third, the court framed its Dobbs opinion as simply returning the issue of abortion to the states and the electoral process. As Professor Petersen noted, Justice Alito wrote, "Women are not without electoral or political power." But as Professors Leah Littman and Melissa Murray have written about, the court does this at the same time that it is weakening our democratic system. Think of partisan gerrymandering and the dismantling of the Voting Rights Act in Shelby County. Women of color in particular are disproportionately impacted by the court's decision in Dobbs, and those same folks, in part as a result of decisions the court itself has made, face barriers to exercising the kind of political power Justice Alito cites. And finally, again, in connection with returning the issue of abortion to the people, the court asserts that Roe and Casey, far from bringing about a national settlement of the abortion issue, have inflamed debate and deepened division. If the expectation is that Dobbs will bring about a national settlement of the abortion issue, the dissent rightly points out that the majority's ruling, among other things, invites a host of questions about interstate conflicts, as Professor Petersen highlighted. As the dissent asks, can a state bar women from traveling to another state to obtain an abortion? Can a state prohibit advertising out-of-state abortions or helping women to get to out-of-state providers? Can a state interfere with the mailing of drugs used for medication abortions? Far from removing the court from the abortion issue, the majority puts the court at the center of the coming interjurisdictional abortion wars. We've seen the start of this kind of interjurisdictional warfare through Texas's SB 8 and responses by states like Connecticut and New York, which have passed shield laws to attempt to protect their residents, medical providers, and visitors from liability that states hostile to abortion may seek to impose beyond their own borders in connection with the provision, receipt, and assistance with reproductive health care. Now, this could be a panel discussion in and of itself, but if you're interested in some of the interjurisdictional issues to rise in a post-Roe world, I'd recommend to you an article called The New Abortion Battleground by David Cohen, Greer Donnelly, and Rachel Rebouchet. And with my remaining time, I'd like to just briefly highlight developments at the state level post-Dobbs. Of course, many states have restricted access to reproductive health care in the wake of Dobbs. There's also an incredible range of anti-abortion bills in state legislatures. A few examples: a Texas bill that would require internet service providers to, quote, block internet access to information or material intended to assist or facilitate efforts to obtain an elective abortion or an abortion-inducing drug. There's a similar proposal in Iowa. There's another Texas bill that would make it a felony for a credit card company to process a transaction for the provision of an abortion-inducing drug. In Utah, a bill effectively outlawing abortion clinics is headed to the governor, who has said he will sign it. This is on top of the bills in various states that would make abortion homicide. Now, here in Hawaii, we have state-level abortion protections, and in October, Governor Ige issued an executive order with various provisions intended to protect access to reproductive health care services. And this legislative session in Hawaii, there are reproductive rights related bills, among them SB 1, which, among other things, would strengthen and clarify the state's protections for reproductive health care services and protect against potential efforts by other states to impose civil or criminal liability or professional discipline in connection with reproductive health care services that are lawful in this state. The state of Hawaii also recently joined a lawsuit by a coalition of, I think, 17 states in the District of Columbia, led by the state of Washington, challenging the FDA's REMS, which is Risk Evaluation and Mitigation Strategy, on mifepristone, drug used for medication abortion, that place what the states say are burdensome restrictions on prescription and dispensation, despite the drug's proven safety and efficacy. Now, post-Dobbs, there is a lot of activity, including in the courts, on medication abortion, and Wookie will talk more about that. So I know we have a lot packed into this hour, so go ahead and stop there and turn it over to Wookie. Thank you again so much for having me.
Thank you, Kaliko, for your valuable insights on how Dobbs will affect other rights and for painting the post-Dobbs landscape on state levels. That brings us to our next speaker, Wookie Kim, who will focus on the litigation around medication abortion in our state and federal courts.
Good afternoon, everyone. It's a pleasure and an honor to be speaking here today. So as just mentioned, I'm going to focus on medication abortion litigation, both pre and post-Dobbs. And the one takeaway that I want you all to take away from from my presentation today is that medication abortion is both a new and old, but now a key battleground in the post-Dobbs era. And this is a graph showing the number of Google searches around medication abortion right after the Dobbs decision came out. And as you can see, there was a huge spike nationwide. And I think that just shows, right, that after Dobbs and what that forecasts for the future of abortion access, many people are now focusing on medication abortion. And so before going into all of the litigation details, I wanted to just cover the basics because not everyone may be aware of what medication abortion is. But in short, it's typically a 2-drug regimen involving mifepristone, which is a drug that blocks the progesterone hormone, which is needed to sustain a pregnancy, that then 36 to 48 hours later is followed by misoprostol, which is a drug that induces cramping and that empties the uterus. So when we're talking about the abortion pill, it's sort of a misnomer because both of these drugs are used today as part of the medication abortion. But mifepristone, the first drug in the regimen, is the one that is subject to FDA regulation, which I'll talk about in a little bit. But importantly, mifepristone has been approved by the US FDA for over 2 decades. It was approved originally in 2000, and that followed several additional decades, or I guess 12 additional years, where other countries, including most notably France in 1988, had already approved the use of mifepristone for medication abortion. Another important fact to note is that medication abortion is now the most common method of obtaining an abortion. And as of February 2022, 54% of all US abortions were conducted through medication. And the last point, and I think sometimes it's hard to really understand the effectiveness and the safety of this drug, because you see competing narratives on the news and in the public sphere. But this drug has an extremely long track record for being effective and safe. When it comes to effectiveness, studies have shown that it's 99.6% successful in terminating the pregnancy. And as far as the safety record, mifepristone has been used over 5.6 million times since it was approved in 2000. And of those 5.6 million uses, only 28 have resulted in deaths. Of course, there's a larger number of uses that have resulted in hospitalization, but even then, that's very low. And in fact, the safety record is better than drugs like Viagra, drugs like penicillin. And so when we talk about safety, it's important to understand, right? You can never obtain a 0% risk rate or a 100% safety rating, but here the risks are very, very low. So why is medication abortion important? I mean, I think it's fairly obvious, but one of the basic points is that it provides women and pregnant people another method of obtaining an abortion apart from surgical abortion. And related to that, it also increases access, because especially nowadays when with the rise and advent of telemedicine, the fact that the evaluation and consultation for medication abortion can occur through telemedicine makes it far more accessible to many people, regardless of their circumstances. It's also less invasive. It doesn't require surgery, and it doesn't require tools going into your body. And so that's another reason that it's a beneficial alternative. And then finally, this is really important as well. There are fewer privacy concerns. You can take the procedure within the comfort of your own home. And not only that, you don't have to travel to a clinic, and you don't have to explain to family or friends why you're traveling or why you're going to be off work or any of that. And on the right is just showing the immediate impact that telemedicine access to medication abortion has had here in Hawaii. This was an article about an early study that allowed the dispensing of medication abortion through mail. And Ms. Dale was on a neighbor island, and she, a single mother, avoided having to come to Oahu to obtain an abortion. So I wanted to now transition into the litigation relating to medication abortion. And in short, for a long time, and in fact, ever since mifepristone was approved by the FDA, it has been subject to what is called a risk evaluation and mitigation strategy. And what that is it's a special set of restrictions that the FDA imposes only when, quote, necessary to ensure that the benefits of a drug outweigh its risks. So it's used very, very rarely. And in fact, of the 20,000 or so FDA regulated drugs, fewer than 2% have such REMS. And of those, 3/4 are opioids, which of course are dangerous. But in 2016, this was the status quo. And the biggest restriction, which has had recent changes, was that there was an in-person dispensing requirement. What this meant was that as of 2016, patients needed to pick up their pill at a health center or in their doctor's office, rather than receiving the pill by mail or through a pharmacy, like for many other drugs. Even though under these restrictions, patients are free to take the pill in the privacy of their own home. And so mifepristone was the only drug that the FDA let patients take unsupervised, but still required to be picked up in person. There are two other requirements that existed back in 2016 that are still in existence today and that are the subject of the lawsuits that Professor Petersen mentioned and that I'll turn to at the end of my remarks. But those were maybe less onerous than the in-person dispensing requirement. And so in October of 2017, ACLU National, and specifically our Reproductive Freedom Project, along with the ACLU of Hawaii, filed Chelius versus Becerra here in the US District Court in Hawaii. And our lawsuit challenged the entire mifepristone REMS, so all three of these elements permanently. And the arguments that we made were that the REMS really had a negative impact and imposed an undue burden on abortion access, not just in Hawaii, but nationally. I think our client's story and our client situation, and I've excerpted an article that was published shortly after we filed the lawsuit, but our primary plaintiff was still is an OBGYN on Kauai. His name is Dr. Graham Chelius. And for all of his patients who sought abortions, because there were no abortion providers on Kauai, he had to tell them, look, go to Oahu to get your abortion. And of course, that was presenting a huge burden. All the logistics associated with traveling, with obtaining childcare was a huge burden. And that's part of the picture that we presented when we filed the lawsuit. Of course, as others have mentioned, there was a disparate impact on poor and single mothers who are disproportionately women of color. And so we asserted arguments. And of course, some of these arguments no longer really have a doctrinal foundation, because as we all know, Dobbs has now said that there is no right to abortion under substantive due process. But the point is, we filed this lawsuit back in 2017. It took many years of developments. And so COVID really sharpened the issue, because obviously the in-person dispensing requirement is very, very, very difficult to adhere to in a situation where there's a global pandemic and people are getting sick. And so in May of 2020, the ACLU, in fact, my co-counsel, filed a separate lawsuit in the District of Maryland called ACOG, the Medical Association versus FDA. And the lawsuit was a little bit more tailored. It challenged only the in-person dispensing requirement and only for the duration of the COVID-19 pandemic. And so that resulted in a bunch of back and forth in the appellate courts, and the district court first granted an injunction against enforcement of the in-person dispensing requirement, but eventually the Supreme Court stayed it. But then in April of 2021, the FDA decided to exercise enforcement discretion and essentially suspend the in-person dispensing requirement for the duration of the pandemic. One other lawsuit I wanted to mention that was filed sort of along all of these other lawsuits or along these other developments is Raidu versus Camacho. So a separate ACLU team filed a lawsuit in the District of Guam, challenging a Guam law that required that people receiving an abortion receive in-person counseling before obtaining it. And so what this meant was that so here's the situation on Guam. In 2018, the last abortion provider on Guam retired. And what that meant was it left a huge void of who would provide abortion care on Guam. And so the plaintiffs in this lawsuit are two Oahu-based doctors who are Guam licensed, Drs. Raidu and Dr. Kaneshiro. They wanted to provide medication abortions to patients on Guam through telemedicine. But of course, this law on Guam that required in-person counseling made that impossible. And so the team filed a motion for preliminary injunction, and the court granted that injunction based on the undue burden on the right to abortion. Of course, there have been developments in this case after the Dobbs decision was handed down. But then in May 2021, our Chelius lawsuit was stayed because the FDA notified our clients that they were going to conduct a full review of the REMS. And so we stayed our lawsuit at that time. And for the rest of the year, the FDA completed their review. And at the end of December 2021, they announced that they had done the review and that they were going to permanently remove the in-person dispensing requirement and also allow pharmacies to distribute the drug. So I understand that I'm out of time. I realize that I'm really bad at time management when it comes to presentations, but the only thing that I'll end with is that obviously post-Dobbs, all of this has been thrown up in the air, and there have been a whole host of new lawsuits filed on both sides of the equation. And so kind of the question is, what is the future going to look like? And I've compiled a few recent news clips showing some of the areas where medication abortion litigation will sort of continue. I think this will have an impact on elections. It will have impact on the way that pharmacies provide the pill. And of course, as Professor Petersen noted, there's also the question of access from overseas. So I'll stop there. Thank you very much.
Thank you very much, Wookie, for providing this overview as well as your valuable insight on the litigation aspect around medical abortion. Next, we will hear from an activist, Nadine Ortega, who will discuss, among other things, disparities amongst women of color in access to abortion care, as well as Hawaii-specific issues.
Thank you everyone for having me. I will be speaking on the issues relating to abortion and reproductive justice from a perspective of grassroots organizing outside the legal field, outside the courtrooms and legislatures. Although these spaces are also important battlegrounds for the fight for women's rights, these spaces are also exclusionary and sometimes disconnected from the masses. The main battleground is not in the courts or the legislature, but in the everyday lives and bodies of women, particularly Black, Indigenous women, birthing people of color, many of whom are often young and experiencing multiple forms of oppression relating to race, gender, class, ability, immigration status, etc. These laws and policies enacted and decided by the upper echelons of society encroach in our lives, often in devastating ways. First, I want to start with a personal story about abortion to kind of tie in the larger issues that I will talk about at the end of my presentation. So I had my first abortion in my early 20s. As many young women, we're often burdened with handling it, dealing with it on our own. I could not tell my parents. I was scared. I contacted my gynecologist, who said she does not really do abortions. But if I really wanted to terminate my pregnancy, she could do it. My insurance at the time did not cover abortions, not even a portion of it. My gynecologist's office quoted me over $1,000 for the procedure, which I couldn't afford. One of the medical assistants, seeing my panic face, recommended Planned Parenthood. At the time, I did not know where to find abortion services. There was no guide or compiled list of places to go for these services. It took a few weeks until Planned Parenthood had an opening. I went there in secret by myself. I was feeling super scared. I elected to do the in-office procedure because they advised me that that would be the safest. And everything went well, no complications. But to be truthful, it was not painless and easy either. You feel some pressure and discomfort. It was not scary, but still scary nonetheless. And also, you have those feelings of guilt and regret along with fear. And the cost of Planned Parenthood was more affordable, but it was still expensive, especially for someone like me at that time. I had like $200 in the bank. So I share this story to show that the struggle to get an abortion here in Hawaii is a very common experience for many women and girls. Around the passage of the Dobbs decision, I was trying to organize women, particularly Filipino women, students from UHM at UH Manoa, and then mothers into a Filipinos for Abortion group because of the often the stigma about abortion in the Filipino community. So from the stories shared with me through our gatherings, I found many connections and commonalities that our choice to have an abortion and the medical care we received were constrained by our identities and status, where we are located in relation to power, particularly by our race, gender, class, ability. So, in Hawaii, we are often hailed as liberal or even progressive, right? While it is true that we have strong reproductive rights protections, however, this has also been used as a reason to not do more. We still have many barriers and limited access to abortion, which is a big problem. To summarize, the biggest issue for the community here in Hawaii is a lack of actual access to abortion care due to logistical, geographical, and financial barriers. On Oahu, we experience an acceptably long wait time. The average time to get an abortion after you schedule with Women's Option Center or Planned Parenthood is almost 3 weeks. The 3 weeks is extremely long while pregnant and in a situation where timing is everything. This can result in essentially forced pregnancies. We know cases of women choosing to keep the pregnancy because the wait time pushed them past the medical pill option and only surgical surgery option, which it's often really intimidating and expensive. Some women report that this has ruined their lives and having 3 to 4 children instead of the 2 they wanted. For many multiply oppressed women, this results in negative health outcomes, pregnancy-related mortality, and birth risks. They also bear disproportionate negative impacts to their academic and professional careers because, as per usual, women bear the burden of childcare and often have to wait to quit their jobs, or school, or drop down to part-time. Many who are already suffering from financial instability are further constrained by the cost of child rearing and childcare and may further go into debt or poverty. On the neighbor islands, access to abortion is even more limited, resulting in forced pregnancies. There is 0 abortion after 9 to 10 weeks on Kauai. There is only 1 known provider on the Big Island, none on Molokai or Lanai. Maui has a Planned Parenthood clinic, but it is still limited because local doctors are too scared and worried about social ostracism. There are also doctors who refuse to perform abortions. Additionally, there has been a decline in the number of abortion providers in the past couple of decades in Hawaii. Women would have to travel from the neighbor islands to Oahu, which is a significant barrier for women because of the cost of travel, as many of the panelists already said in here. This is especially hardest on Native Hawaiian, Pacific Islander, and Filipino communities, particularly those who are young, houseless, poor, immigrant, those facing DV issues, and those who are uninsured or underinsured. These are serious issues happening in Hawaii right now. We cannot act like everything is okay because we are in a quote unquote blue state. These are issues that must be addressed. And we need to engage with community, especially women who are holding oppressed identities, who will continue to suffer if we do not change things. The legislature just passed SB 1, a bill that protects out-of-state patients and doctors from legal attacks from hostile states. Doctors are terrified of being sued, so they are threatening to stop providing abortions without this law. Providers threatening to cease services is a real threat, and it is important to provide these protections. However, the legislature decided to pass only SB 1, the legal shield for doctors and out-of-state patients. But they killed HB 1343, a bill advocated by many community advocates. The legislature could have passed both bills. HB 1343 was a result of consultations with members of the community, such as youth, mothers, sex trafficking survivors, women, and immigrant rights activists. The purpose of this bill was to create a statewide abortion access coordinator office to address the limited or no access to abortion in Hawaii, but it was not passed. I want to further highlight the problem of the limitations of these systems and processes by pointing to how we frame abortion. The headline from Wednesday's paper announcing Hawaii Senate passing of SB 1 declares right to choose. It tells you the value system, the liberal framing of this issue, which is individualistic, white, American, very privileged. The rhetoric of choice, freedom of choice, is very often thrown around. But choice and the ability to make certain choices are not equal. Yes, women as a group overall have more power now, but we need to think about women who are laden with other forms of oppression in addition to sex and gender. We live in a society structured by systems of oppression such as racism, misogyny, classism, ableism that compound to produce and reproduce injustices. So what we need and need more of are community-led solutions. So I wanted to share my screen to just point to one example of a community-led, community-engaged governance that needs to be expanded and supported. So let me just share my screen quickly. So this is the Hawaii Abortion Collective and Guide. As I point to as examples of community engagement and governance that needs to be expanded. Before the Hawaii Abortion Collective, no one knew the scope of access or barriers to abortion services in Hawaii. Hence, community feedback and engagement is critical. So this is the website. Hawaii Abortion Collective is a coalition dedicated to strengthening abortion rights in Hawaii, to improving access to abortion care on all islands. Hawaii abortion care includes licensed medical providers, public service attorneys, faith-based leaders, government officials, anti-violence experts, abolitionists, and community organizers and organizations united in our respect for women and people who can get pregnant. We come from family-oriented, mahu inclusive, and women-led cultures. And this is the guide. I'm not gonna go through the whole thing, but I wanted to just kind of show what's inside the guide, if my internet is working properly. So this is what's inside. So if somebody could provide the link to the attendees, that would be great. And that's all I have for my presentation. Thank you all.
Thank you so much, Nadine, for being here and sharing about your on-the-ground efforts to fight the disparities in access to abortion care. But most importantly, thank you for your bravery and sharing your powerful personal story with us. It's a deeply emotional and scary experience, and the anxiety that women feel during the long wait times and having to go through the surgical procedure as a result of the delay. I stand with you as someone who went through a similar experience, and 1 in 4 women will have an abortion by age 45. So resources like the Hawaii Abortion Collective and Guide are critical to our community to help increase the access in a timely manner. So thank you to all of our wonderful panelists for your presentations. I know that was a lot covered just now. So we'd like to open it up to everybody to share any of your reactions or responses to the presentations of your co-panelists really briefly, and then we'll close up with the final question.
Maybe I'll go ahead and jump in and go ahead and ask everyone our final question, which is, in a 1 to 2 minute response, what would you say to young lawyers or advocates who may take up these fights to protect women's abortion and reproductive rights, as well as any other civil rights and liberties that may be at stake?
That's a very big question. I think it's very, very important to build alliances. And I do think that there will be some possibilities for building alliances, even with independents and moderate Republicans. And there are some out there who are really, really shocked by the fact that Roe v. Wade was overturned. A lot of Republicans never really thought it would happen. And a lot of Republican legislators thought they could, on one hand, promise the anti-abortion movement that they were working hard to appoint judges who would overturn Roe v. Wade, but they never really expected it would happen. And now there's this incredible political fallout. And I honestly think that there will be opportunities. As I said in the end of my presentation, they may not always be philosophically the outcomes that affirm all the rights we would like to see affirmed, but they might help to mitigate some of the harms that Nadine just mentioned, especially in very, very conservative states. And the second thing I would say is pay attention to the science, because the science is changing so quickly. And activists are very creative. Increasingly, we're seeing abortion pills being advertised as late period pills. In other words, you don't even necessarily have to take a pregnancy test. You may not even know you're pregnant, but you can take these pills. And if your period is a few days late, it will bring on your period. And it may be actually a very smart, creative way of getting around some of the laws that are harshly targeting women. It doesn't take away the inequality or the suffering, but it might be a way to help mitigate it. Thank you.
I can go because actually Professor Petersen raised a point that I think I would share, which is that, to not just to basically think creatively, because, with an ever evolving landscape, and especially on really difficult issues like this, you constantly have to adapt. And so part of it requires to not losing faith in sort of the battle and realizing that it's an important one worth fighting. Because obviously when there are losses, it's really easy to just give up. But instead of giving up, realizing that there are new ways, new paths forward that can ensure increasing access. And so recognizing that, I think, is the message I would send out to all young aspiring lawyers.
Yeah, I know we're sort of over time, and folks have already said really good responses to that question. I'll just sort of amplify what Wookie said towards the end about not losing faith. The direction I came at this, from my presentation was about the Supreme Court. I think it's easy to despair given the composition of the Supreme Court and the enduring nature of that composition. But of course, this work is so important. It has always been important. It is very important now for young folks who are interested in this to do this work. The pendulum will swing.
Okay, so I'll go ahead and wrap up our panel. But before we all hop off, I was wondering, we wanted to get a couple of photos of this panel. And if that is okay with everyone, then I'm going to go ahead and count down from 3. And then our law review members will go ahead and take our photo. All right, so I'll count down. Ready? 3, 2, 1. Great. Thank you, folks, very, very much. We really enjoyed being on this panel with you, and we really appreciate all of your time and insight and patience. Thank you.
Thank you very much.
Thank you very much.
Bye, everyone.
Thank you. Bye.